All right, everybody, have a seat. We should have started 20 minutes ago. I realize lunch went long, but unfortunately, I have a hard stop because I'm doing another presentation right after this. So I'm going to get us through as much of the material as I can. My colleague Harrison will be taking over for me after the break at 2:45, and I'm confident he can get us the rest of the way, but I just want to make sure that we cover everything in appropriate depth. I'm happy to take questions as we go along. I would ask, just because time is pressing, to keep your questions general. I'm not here to talk about specific circumstances, what's going on in your specific building. I'm happy to do that offline. We've got the clinic here to do that, or you can call me Monday. But right now, let's focus on things that can enlighten everyone. So we're the Office of the Tenant Advocate, set up in 2005. I think you're familiar with us because you're here today. And we're glad you are. This is a brief overview of what we're going to cover today. This is for the whole day, my session and Harrison's session this afternoon. I'm going to try to take us up to and through security deposits and see if we can make sure that you guys are caught up on your rights through those issues. So we'll start from the beginning, the application. And again, ask questions at any point through this. The landlord can require personal information from you during your application, okay? They can require very personal information during the application, but some things are limited. So they can ask you for your ID, they can ask you for your social security number, they can ask you for your rental history. They currently, you might have heard Councilwoman Che talking about civil expungement for evictions, but right now they can go back your whole life in terms of evictions, cases you've had filed against you, things like that. But there are some limits to what can be on an application. First of all, co-signing. A co-signer can be required if that's what it takes to bring you up to creditworthiness or to having income that can afford the place. In the landlord's estimation, and they can't forbid co-signing. So if a landlord says, oh, this is the minimum income I will take for this apartment, they can say, I don't want a co-signer, but they can only say that as long as it's not discriminating against a group of people by not allowing co-signers. Typically that's students, and that's what the law says specifically. A landlord can't say no co-signers allowed if the real reason to say no co-signers allowed is I don't want students, because students almost always need a co-signer. Criminal record screening. This recently changed. So it used to be that criminal records were fair game for landlords to look at when you applied to an apartment. Now we've got a regime that looks a lot more like the ban the box when it comes to job applications. So the landlord cannot, as soon as you put your application in or come in to talk to them, say, do you have a criminal background? They can't just run a criminal background check on you full stop. Instead, the landlord can look into your credit, look into other things, and give you a provisional offer saying, I will rent you this place pending my criminal background check. And then if they find something on that check that's problematic, and there are limits on how far back they can go for certain crimes, but if they find something that they're allowed to take into account and that's a problem for them, they can say, okay, my offer is withdrawn. But first they have to come to you and make the provisional offer. And this prevents the situation where a returning citizen, you apply to 50 different places, you get 50 different no's, and no one ever tells you why. And you don't get an opportunity to explain or defend your record because you're never being given an opportunity to know what's holding you back. Okay. Holding fees. And was there a question on criminal background? Oh, I thought I saw a hand. Holding fees. The landlord can demand a application fee, okay, a non-refundable application fee. That's something that typically you're paying to help the landlord defray the cost of running the background check. The landlord can also demand a holding fee to hold the apartment for you during the application process. Now, keep in mind, if you've paid a holding fee, first of all, you should get a receipt. It should say that the holding fee is refundable. And the landlord is at that point obligated to hold the apartment for you. That is itself a contract. Okay, the promise, I will hold this apartment open for you while I do your background check if you give me $100 to hold on to or whatever it is. That's a separate contract. It's what's called an option contract. We'll get to that because it's the same kind of contract you get under TOPA. Is essentially an option contract. You have the option to rent. You have the option to buy the building. And so the landlord can't take a holding fee from you and then say, you know what, the next day I found someone who wanted to pay more. So here's your holding fee back, get out of here. Now they can take the holding fee and then run their background check and say, oh, I didn't like what I saw. That's very different. Does that all make sense? Great. A couple pitfalls when it comes to identifying the unit, because we do get people coming into our building saying, I went to rent a place at 1600 Pennsylvania Avenue, and I got there, and the guards wouldn't even let me in the door. Keep in mind your personal requirements, carefully search using the available resources, and beware of these signs of a scam. And you'll find them in your booklet as well. These dangerous red flags. Sight unseen, renting property that you haven't seen is not a good idea if you have an option. Listings and rents that sound too good to be true are rife on Craigslist in particular. A lot of times when a landlord puts an apartment up for rent, scammers will grab that ad and copy it, except they'll make the rent, 1/10 of what it was, and just try to get a few $100 from someone who thinks they're making a security deposit. So particularly if you see an apartment advertised for $2,000 a month and you see the same apartment advertised for $200 a month, you got to know that's a scam. You should not transfer any money until you've seen the apartment and until you've seen proof that this person has access to that apartment, that they're not just standing on the front lawn showing it to you. They have a key. They can get in the door. They're really the landlord. Here are some of the things that a landlord is supposed to have before they rent you an apartment. They're supposed to have a basic business license. This is a license that the city gives to anyone who's running a business, stating that they've paid their fee, they've done what they needed to do, and the city licenses them to conduct business within its limits. A certificate of occupancy is something that DCRA issues to all buildings that are not single-family houses. And the certificate of occupancy, it attests that the building is safe for people to live and be in. The DCRA comes out, they see what the building is used for, and they're attesting that it's safe for that use. So it's got floors, it's got a roof, it's got walls. They are also supposed to be registered with the Rental Accommodations Division. Now, the basic business license and the registration generally happen about the same time, is my understanding. The Rental Accommodations Division, so DCRA you see in these first two, they're the ones whose job is to oversee construction, among many, many other things, is the construction up to code. They're the ones who send out the housing inspectors. They're the ones who say, is this building safe? The Rental Accommodations Division are the ones who oversee rent control. They're the ones who oversee whether the Rental Housing Act is being followed. Is condo conversion being done illegally? Is the landlord illegally giving people notices to vacate? So that's why there's two different departments doing this work. And the registration with the Rental Accommodations Division is necessary because they're the ones who decide, is this unit under rent control or is it exempt? And we'll get to that when we get to rent control. A housing provider's failure to be properly licensed, I don't usually like to read right off the screen, but this one is so important. A housing provider's failure to be properly licensed does not render a lease null, void, or unenforceable. The lease will likely remain, unless there's some other reason, the lease will remain binding on all parties. So if you sign a lease with someone who does not have a business license, does not have registration, doesn't have a certificate of occupancy, they're in trouble. They haven't done what the law said they have to do, and they could be fined by the city. There could be other consequences that we'll talk about. But it does not in any way mean that you are not bound to the lease to them, and they are not bound in the lease to you. You still have the right to be the tenant. They still have the right to rent. Here are some of the disclosures that the landlord is supposed to provide to you when you apply. This is before you ever get the lease. These are the things the landlord is supposed to give to you as part of the application process. Is there a question? Oh, I'm sorry. I thought, okay. The basic business license number, which obviously lets you know that they have a basic business license. The claim of exemption form or registration form, which lets you know whether the property is under rent control or not. The certificate of occupancy, except for single-family dwellings, and the applicable rent. I mean, you wouldn't rent a place if they didn't tell you how much it was, I hope. Finally, the presence of indoor mold in a prospective unit or common area in the last 3 years, unless the mold has been remediated by a licensed professional. Now, I believe we'll get to mold in the afternoon, but I will say here that the DC mold law splits mold problems into two broad categories. Ones where there is more than 10 square feet of visible mold, and ones where there is less than 10 square feet of visible mold. When there is less than 10 square feet, the landlord does not have to bring in a licensed professional to remediate. They can get a handyman to do it. They still have to do a good job. They still have to do it according to the way the city says you do it, but they can get just a general contractor to do it. The bigger scale problems have to have a licensed professional. But regardless of the size of it, if the landlord has dealt with mold in the past 3 years and they didn't have that licensed remediator out to fix everything, they have to tell you about it when you move in, or before you move in, when you apply. Now, here are some additional disclosures that just apply if you're under rent control. And again, I think in the afternoon, maybe this morning, we'll get to rent control and we'll get to where the exceptions and exemptions are. But if you are under rent control, they need to let you know, are they about to jack up the rent under the rent control program? So any pending tenant or housing provider petitions that may affect the rent. So that would include if they've recently applied for, say, a capital improvement where they're asking the city, please allow me to jack up the rent so I can fix the roof. If that's still pending before the city, they have to provide it to you. If the tenants in the building have recently sued saying you're charging too much rent and you have to lower our rent, they're supposed to let you know that too. A copy of any housing code violation report issued by DCRA within the last 12 months. Now, I don't know that I've ever seen that actually done. It should be done, but it's not terribly common that I've heard people say, oh yes, the landlord provided me with that. You can find those things yourself if you go to, yes ma'am. Disclosure that someone had died in there? Got it. So the question is, does a landlord, I have to repeat the questions for the closed captioning. So the question is, does the landlord need to disclose to a prospective tenant, someone who's thinking about moving in, that someone had previously died in the unit? Different jurisdictions have gone different ways when it comes to the question of whether somebody dying in a unit is a valid ground for anyone to make a decision based on, put it that way. So in some circumstances, some states have said, if you're selling me a house and I want to buy it and you don't tell me that the previous tenant, say, committed suicide in there, that you've defrauded me in some way. DC is not one of those states, to my knowledge, where the fact of a death in the property is considered a material fact. So and again, we're talking about if you're selling real estate, the general rule is you can't dishonestly withhold a material fact. In the rental context, I think it's even less likely that a court would say that the fact that someone had died there before was material to the question of whether you picked up the tenancy. So I do not think that the landlord has to disclose that to you. Sorry to say. But I'm happy to take any other questions on that point or any other. So a pamphlet published by the rent administrator that explains the requirements for rent increases. So that's just a standard pamphlet you get with your rent-controlled unit. And there are also, these disclosures are basically just a printout of a portion of the housing regulations, that portion being the housing code, which is what lays out what the bare minimums are for habitable housing such that will allow human beings to live there and not declare it uninhabitable or not. Yes, ma'am. Inspection by the Department of Consumer and Regulatory Affairs or inspection by the landlord? Okay, so there are two potential government agencies that could be conducting regular inspections in your apartment. One is the DC Housing Authority, if those units are inhabited by someone who is on a housing choice voucher or otherwise receiving city money to help assist with their housing. People who are in that situation, the housing authority on a regular annual basis, I believe, or sometimes semi-annual, comes and inspects the apartment to make sure it meets federal requirements. So those would be a regular thing. The other possibility is that the city's own housing agency, the Department of Consumer and Regulatory Affairs, is coming out to inspect. And typically that only happens if the tenant has become dissatisfied with the housing conditions and has called the inspector out to come inspect their apartment. We don't have a proactive inspection regime in DC. So somebody has to call DCRA and say, I want you to come and look at my apartment because my landlord's not keeping it up. So the second is more likely, but it could be either. I'll get to you in a second, sir. Well, neither is spontaneous. Both of the types of visits I'm talking about would be made in the context of appointments. The only way that DCRA or indeed DCHA or any of these government agencies can enter someone's property without notice and without their permission is in the context of a warrant, which there is such a thing as an administrative warrant to do that, but I'm sure that's not what's happening in your building. I'm sure that the landlord and the tenant know when the inspection is happening. So yes, sir. So from the point of view of the regulatory agencies, if the fact that their inspection is happening soon causes the landlord to fix up the apartment, good. Yeah. Yes. Okay, well, I'm sorry you went through that. The question is, okay, so It may have been. The question is that your landlord allowed an administrative agency, and we don't know who, some agents of the government, to come into your dwelling in order to do an inspection without giving you notice. And we'll get to notice, I think, this afternoon, but your landlord has to give you 48 hours notice before they can enter your unit without your permission. And they have to do it during normal business hours or Saturday, 9 to 5. And generally speaking, if it's to inspect the unit or allow for an inspection of a unit, that's proper. If they haven't given you the requisite notice, that's not proper. It is technically trespassing. However, your damages, what you would be able to sue for and get compensation for, would be any damage that was done to your property as part of that process. Because unless you have quantifiable damages, the real damage, which we all know is the real damage, which is the damage to your peace of mind and your sense of security in your home, is not something that courts feel that they can compensate for because you can't attach a dollar value to it. It's too hard to evaluate the worth. And so if they stole some of the money that you had, then that's a trespasser stealing your money, and that's not change. Well, frankly, if they stole your money, it has nothing to do with whether the landlord gave them permission to be there or not. Someone stole your money. That's theft. That's a crime. And so, okay, so I don't want to get too into the individual circumstances of, and I don't know who these people were, so I can't really advise you on what to do next. Yes, ma'am. Uh-huh. So whenever, okay, so the question, if I understand it, is I was talking earlier about the things a landlord needs and what regulates their behavior. Do those things continue to apply if the landlord changes the use of the building? They turn a single-family home into a three-family dwelling. The answer is the certificate of occupancy is supposed to be updated every time the use changes. So if it goes from a rooming house to a single-family dwelling to a two-family dwelling, there's supposed to be a new C of A every time. The landlord is supposed to have an active business license that describes what they're actually doing. So the fact that they had one a while ago that says they are in a different business than the one they're now in doesn't help. So their single-family license doesn't help now that it's a three-family dwelling. And as far as rent control goes, that depends on whether something has changed that would impact rent control. So we'll get to that when we get to rent control, because it's a lot to jump into. Yes, sir. And then we should move on. Okay. So the question is, and we will get to housing conditions, but I mentioned that DCRA has housing inspectors who come out and inspect housing. There's also a in DC called Housing Conditions Calendar, which can hear cases from tenants against landlords about housing, and they have their own inspector, who's a DCRA inspector who just works with that judge. And what do you do if you've got two DCRA inspection reports and they say different things? As a matter of law, there is no difference between the reports, and the judge will have to decide which one they give greater weight. Practically speaking, the inspector who works with the judge every single day, talks to them every single day, and is trusted by them. Which report do you think they're going to listen to? That's called Housing Conditions Calendar, and it's in Superior Court. We will get there. You're also supposed to get a lead safety pamphlet that everybody's supposed to get. That's a federal law, actually. And a tenant-led rights form that the DC Department of the Environment issues. in any rental, whether there's a chance that there's lead there or not. A tenant-landlord relationship is established by a contract. A lease is a type of contract. A lease is a contract to rent something. So when we talk about a lease, it's just one species of contract. Under a lease, the landlord and the tenant have certain rights and obligations. There's two important points I want to stress here. One is what's starred here. Like any other contract, almost any other contract, a lease may be written or oral. Now, there is 6 categories of contracts that can't be oral, but a lease is not one of them. Yeah, it's just not. The other thing I want to stress is, and we'll get into this, I have a feeling again, when we get to housing conditions, the rights and obligations in the lease are generally considered independent of each other. So your obligation to pay rent to your landlord is independent of whether the landlord keeps the place up to code, in the same way that the landlord's obligation to keep the place up to code is independent of you paying rent. If one party doesn't do what they're supposed to do under the contract, we're going to talk a lot today about what your options are to make them do the right thing or to get compensated. But it's not the type of contract where, well, if you don't do it, then I just don't have to do it. Some contracts work that way. Those are called, mutual promises or dependent promises. But these are generally construed, unless it says so very specifically otherwise, to be independent promises. You don't need a written lease to establish a tenancy. A handshake and the payment of rent will do it. The landlord may not change the terms of the lease without your agreement. The landlord cannot modify a lease. Nobody can modify a contract that you're in with them unless you agree. It requires 2 parties, a meeting of the minds, to make a contract, and the only way to change a contract is to make a new contract. After the initial lease term expires, and this is one of the oddest artifacts of DC law, the tenant continues to have the right to live there indefinitely, month to month, on the same terms, except that the landlord can increase the rent. And how much the landlord can increase the rent depends entirely on whether it's under rent control or not. If it's under rent control, as we'll get to, then it's a certain amount each year. If it's not under rent control, it's whatever the landlord thinks they can get. But in either case, you get to stay as long as you continue to follow the rules in your initial lease and pay your rent. And one of a series of other conditions don't happen to come up, and we'll get to those when we get to eviction. Things that are usually not in your control, like that the building's going to get knocked down. Yes, ma'am. What I'm saying is, if you're living somewhere month to month and the landlord increases the rent legally, I'm sorry, the question was, can you continue to stay in a place even after the landlord raises the rent? Yes, as long as you pay the increased rent. But you have to pay the rent increase, right? If it's legal, if the landlord has legally increased the rent, you got to pay the rent increase. Yes, ma'am. Okay. Okay, so there's a couple questions nestled in there. The question was, what happens to my lease when ownership transfers, and if I need to refer to my lease, is it the old lease, is it the new lease, and who do I get it from? First of all, if the ownership of your building transfers, and this is not considering the tenant opportunity to purchase, just the ownership transfers for whatever reason, your tenancy remains unchanged other than who you write the check to each month. Your old lease continues in full force and effect. You continue to be a tenant. It doesn't by itself change your rent. And the landlord cannot make you sign a new lease. So I understand you signed an addendum, but you didn't have to. You were not required to sign an addendum. Okay. Well, if you did, you were not required to, and if you didn't, you don't have to. Now, again, the landlord can raise your rent, and the landlord is allowed to say, hey, I have this newfangled lease that I really want to get everybody to sign. If you sign it, I'll charge you $900 a month for rent. But if you don't sign and you stay month to month, I'm going to charge you $1,200 a month for rent. The landlord is allowed to say it's more valuable to me to have people on leases than month to month. But what they can't do is say, you got to sign this new lease or get out. That's not how it works. Your second question was, who do I get the lease from? Whichever the controlling lease is. Please, well, whatever you signed most recently is the essential issue. Please, when you sign a contract, retain a copy of the contract. The landlord is required to give you a copy of the contract, including if you e-sign. They have to provide you with a copy. If your landlord, if you sign a contract of any type, but particularly a lease, which is a long-term important one, and your landlord snatches it up from you and runs out the door and says, haha, no copy for you, call us, go to court. You know, that's something worth going and getting a temporary restraining order over for a judge to say, you know, give her or him a copy of their contract, or sit in jail for as long as you'd like until you decide you want to run your copy machine. Yes, ma'am. Continues to be in full force and effect. And okay, so I don't want to get again into excessively individual circumstances, because I want to keep things. Yeah, so I understand your question, ma'am. I don't want to get into unless anybody else here has a 20-year-old lease that they can't locate. I don't want to get into very. No, if the ownership that you got the lease from no longer exists, and you had a lease for 20 years and you can't find it, that's on you. No, they're not required to have a copy of it. Yes. Sure. So when ownership changes, your handshake month-to-month lease, and when we say a handshake lease, we just mean the terms of the lease are supplied by the defaults under the law. There is an entire default lease. It's not something you can look up and read. It's kind of in the minds of judges, but it's out there. Your default handshake lease remains a default handshake lease. Nothing has changed in terms of your obligations, your duties, your rent. The new landlord may have new plans that may impact your life, but nothing about your legal situation changes. I'm saying that your lease is the default lease under DC law, yeah, 17 years ago. Sure. So yes, so to answer both of your questions, if the last lease you signed was 17 or 20 years ago, that's the lease that controls. If it cannot be found, then like you know, the lost will of William Randolph Hearst, you go and you look, and if you can't find it, then people have an argument about what it said 17 years ago. And guess what? You're probably the only person from 20 or 17 years ago who remembers what it said. So if it can't be found, it can't be found, and it's just one of those great mysteries of life. It's a lost document, and probably they kind of have to take your word on to a reasonable extent on what the terms of your lease were. They can certainly argue. Yes, sir. So, yes, first part of the question. The question is, are house rules part of a lease that you can be held to? We're going to get to that. I was actually seeing if it was the next slide. The answer is yes. It is allowable for a lease to refer to house rules, and for those house rules, therefore, to be incorporated into the lease, and the violation of house rules to be a violation of your lease. What's the other part of your question? I think I understand. Yeah, what if the owner has the unanimous power or the undivided power to change house rules willy-nilly, and therefore they can put whatever terms they want in the lease and say you're in violation? Is that legal? The short answer is probably not. The long answer is there's an idea in contract law called an illusory contract or an illusory promise. It's a promise that seems to be something real and binding, but that when you pull on the thread turns out to be an illusion. So if someone has said, you're going to paint my room and I will pay you if I like your work, because liking your work is entirely in their control, you don't really have a contract. You've got an illusory contract. And a lease that says house rules are part of your lease, but I, the housing provider, have, for any reason or no reason at all, can change the house rules anytime I want, and I do it answering only to me. Those things in the house rules then start to seem not like part of a contract, but like an illusory promise that you made, because the landlord has total control if they can just change the house rules to say, why can't I just change the house rules to say everybody has to move out in a month? So, yeah, probably not, but it depends on the facts and circumstances. Any other questions? Or yeah. Well, the question is, so the question is about rent control and exemptions to rent control. We will get to rent control, so I want to save that for now. Yeah, that's part of what you're talking about refers to rent control, and we'll get to that when we get there. The historical designation in and of itself had nothing to do with rent. It only has to do with what you can do when you're constructing or rehabilitating a building. It has nothing to do with what you do inside the building. Okay, so things to look out for in a lease: additional fees, like every time you call and say you have a housing conditions problem, you have to pay a $50 deductible. Those are the kinds of things you want to avoid. You want to be aware of what services are and are not part of the lease, because that's often a source of conflict. Beware of leases that contain blank spaces that somebody can fill in after you're done. Write NA in them if they're not applicable to your situation. Missing landlord contact information is one of the biggest red flags, in my opinion. If you want to enforce your will against the landlord in any forum, in any court, if you want to have recourse to the law to protect you, you have to be able to serve papers on that person. And if you don't know where that person lives, or if you only have a P.O. box, which cannot be served, you can't serve a P.O. box, it can take years, and the hiring of a detective to successfully bring a lawsuit against a landlord in those circumstances, and I have seen it. So please know where your landlord lives. If they live outside the city, they are supposed to have a registered agent who lives in the city who is authorized to receive papers on their behalf, and therefore you can serve the papers on that person to sue them. If they live in the city, they don't have to, but you should have their address to serve them. Don't rent from a P.O. box. Yes? Mm-hmm. So, right. Okay, so the question is, once again, the ownership of my dwelling has changed. The new landlord wants to charge new fees but hasn't given me a new lease. The first part of that answer is what I've said before. When the ownership changes, your lease does not change, except who you make the rent out to. Your old lease continues to be your lease. The second part is, if your landlord is charging you fees that are not in the lease, that's not allowed. They're breaching the contract. They can't charge you fees that you haven't agreed to. They can't claim that you, under your contract, owe the money that you didn't agree to be part of the contract. Now, if you're not under rent control, or even if you are to a certain degree, the landlord may not be able to charge you fees, but they can raise your rent. But they can't say, yeah, you owe me $75 because I had to fix your air conditioner or whatever. No, if that's not in the old lease, that's not in your contract. Okay. Excessively high late fees, those are now capped at 5%, and we'll get into late fees in a little bit. And then lease addendums, house rules. Like I said, the landlord can't use house rules as just their blackboard to write up things they want tenants to do that day, but at the same time, it does leave a lot of discretion to the landlord when there are house rules in effect. So be careful before you agree to a situation with house rules. Look at how those house rules are going to be made. Do tenants have weigh-in? Is there democracy? Are they voted on? Find out what you're signing yourself up for. Here are some lease provisions that just can be problematic. First of all, grace period on late rent. 5 days is now the minimum grace period that the law will allow landlords to have. They have to give you 5 days after the rent comes due, which is usually the first, to pay your rent without getting a late fee. But that does not mean that your rent is on time. If you pay your rent on the second or the third, you don't have to pay a late fee, but you did pay late. And that can become a problem if the landlord says you're a chronic late payer, because chronic late payment of rent is a lease violation. It's a breach of your contract, and it's something the landlord can evict you for, even if the landlord's never given you a late fee. Now, I've never seen it where someone's been evicted because they pay their rent 4 days late every month. I've never seen that. But if somebody who's had a lot of problems with the landlord, has had problems paying rent some months, not paying it other months, in particular, if you get a 30-day notice to vacate saying that you pay your rent late, and then the next month you pay on the second, guess what? Your rent was late. You're now getting evicted. So just be aware that rent's not due on the 5th just because you don't get a late fee before then. Watch out for house manager provisions that say that you have to have one tenant who's the only one who deals with the landlord, just because it is, in my experience, a recipe for drama, conflict, bad blood, accusations of dishonesty and dishonest dealing. Everybody who has to pay rent to the landlord and has to abide by the terms of the lease should be able to contact the landlord. You shouldn't have to funnel everything through one person. And group leases that require tenants to move out, that if you move out, you have to find new tenants to replace you or still be held liable. We may get into a little bit, depending on the interest, the mess that is joint and several leases in this city, and therefore the mess that group living is when people are on one lease but there's multiple unrelated people. When some of those people want to move out and some don't, it gets very messy, it gets very complicated, and it's not entirely clear what the law says is the right answer. What I can say is that something that says you have to find new tenants to replace you or be held liable, if all the tenants want to move out, I do not believe that's enforceable. Now, I wouldn't sign it anyway because I don't want a lawsuit, but the idea that, oh, we want to end our tenancy, but you got to find new tenants, not if I'm month to month, I don't. Does that make sense to everybody? It's a way to try to lock you into a tenancy forever, and it's not a good idea. This list here, which I'm not going to read through in full to you, are unenforceable clauses. So these are ones that are either explicitly stated in the law as not allowed or time-tested and tried in the courts You'll find this in your booklet as well. Time-tested and tried in the courts as provisions that the courts will not enforce. You can run a pen through them because the courts won't enforce them. I mean, I don't literally run a pen through them, but you can act as if they're not there. Not that it's a good idea to sign a lease that's got a bunch of stuff you know is illegal in it, but the landlord's not going to be able to enforce it against you. Beware of questionable clauses. These are ones that are not necessarily illegal, but that can cause major problems, like excessively complex arrangements for the payment of utilities. I've seen many times where a tenant finds out they've been paying utilities for the landlord too, or they've been paying utilities for another tenant who's buddies with the landlord. Strange ones that give the landlord judgment calls to make about who's using too much water. There's a lot of ways that this can go bad. Requirement that you take responsibility for furniture left by the previous tenant. Don't do that. You don't know if it has bed bugs. You don't know. You might not find out for 2 months that it has bed bugs. Excessive limitations on conduct with words like immoral and annoyances. These things, first of all, annoyances is a real red flag to me because I don't know how in the world you define that. And usually people who think that you should be able to kick someone out of their living condition because you find them annoying are disasters as human beings in many ways, not just in that phrase. Likewise with immoral, and we've seen all kinds of leases. I've seen leases that where you were not allowed to eat meat or any animal product or provide it to your children on pain of eviction. I've seen situations where you are not allowed to use any appliances in the apartment without the landlord's express written permission. Don't sign, yeah, no, I know. Don't sign anything like that. Pre-signing a notice to terminate. I haven't seen this really go to court yet, but some creative landlord's going to try it sometime where you sign your lease, and at the exact same time, you sign a letter that says very solemnly, I hereby say I'm moving out on such and such a date. And then when that date comes around, they try to say, oh, we're not evicting you. You said you were moving out. Remember, back when you moved in? Oh, and then if you don't move out, you're a holdover tenant, and I can charge you double rent. Don't sign that. Yeah, it's terrible. I don't think that it's going to be successful, but landlords try all kinds of things. Onerous limitations on subletting. Be aware of what your subletting rights are when you look at the lease. There's 2 regimes of subletting in DC. There's 2 ways that the landlord and tenant can agree on how to handle subletting. One is no subletting under any circumstances, period. The other is subletting if the landlord allows it, and if the landlord agrees to that, they have to be reasonable about the terms they set for subletting. So the reasons that they don't allow a sublet have to be, you know, this person's not creditworthy, their income isn't high enough, they have a bad rental history. Objective things about the person you've brought to them to sublet. It can't be, oh, well, you have to pay me $1,500 to sublet. Or, oh, you know, I don't like you because you were mean to me, so I won't let you sublet. It has to be objective, reasonable, rational. Or it can be no subletting at all. A walkthrough or a move-in inspection is an extremely good idea. I get a lot of people in my office who, let me see how much further we've got till security deposit. We're almost there. We got 5 minutes to go. I have a lot of people come into my office who have a dispute with their landlord about whether they did damage to a property, and they have a bunch of beautiful pictures of what the place looked like when they moved out, and they have nothing showing what it looked like when they moved in. That helps you sometimes. It really helps if you have pictures when you move in. Because if you move in and the cabinet is cracked and the landlord says, I promise I'll fix that, it happens all the time that then you move out and the landlord says, you cracked my cabinet. I know your landlord seems very nice when you move in. Sometimes they are very nice, but sometimes they're not. And a lot of times landlords will try to hit you with things that previous tenants did. So take pictures when you move in. Yes, ma'am. That is sage advice. So the comment was, if you don't have it in writing and you don't have pictures of it, it wasn't said and it wasn't seen. That's a good way of putting it. I've heard it put videos or it didn't happen. You know, you see that on the internet a lot. When you're talking about, it's a little different with Movein because you've usually already signed the lease, but particularly when you're talking about signing a contract, things that were said before, things that were agreed to orally, not only is the court not going to say, oh, the contract says X, but you agreed on Y, so I'm going to ignore the contract. Usually the court won't even let you mention Y. They'll say it's the parole evidence rule. I won't even hear this evidence. I don't want to hear what was said. I just want to see the document. So be careful about oral promises, about things that you can't document. There's nothing wrong. I love email because not only is it in writing, not only is it kept forever by companies that I assume aren't going to disappear like Google or Yahoo or whoever, but it's time-stamped. You can show when the email was sent. And there's nothing wrong with saying, you don't have to say to your landlord, oh, you say you'll fix this? Send it to me in writing. There's nothing wrong with just sending the landlord an email afterwards saying, thanks for coming over today and taking a look at the cabinet. I'm so glad to hear you'll fix it soon. That's all you have to do. And if the landlord doesn't respond, well, if you had no idea a cabinet was broken and someone sent you an email saying, I'm so glad you're going to fix the cabinet, you would respond. You would say, what the heck are you talking about? Yes. Oh, yes. The court, so I can clarify. The question was, how can it be that the court won't hear oral evidence if a lease can't be oral? I was saying specifically that courts usually won't hear oral evidence about what went into a written contract. So it's only in the context when there's a written contract, and it's just talking about what went back and forth before you signed the contract. So if there's an oral contract, that rule doesn't apply at all, because all you've got is oral. So the court will hear all that evidence. What I'm saying is if the court has a written contract in front of it that says signed September 12th, and you say, but on September 11th, you said if I signed it, you would fix the cabinets. The court's going to say, I'm not even going to stop. I don't even want to hear that because this says September 12th and it says this is your contract. Okay. Let's see. Take diligent steps to avoid future responsibility for damages caused by others. Don't accept occupancy of a unit that's uninhabitable or not up to the conditions promised. We get this question a lot, and it is very risky and often difficult to void a lease in DC, to say the housing conditions here are so abominable that I'm just walking away from my lease and you, landlord, can't come after me. Call us before you try to do that, but if you are going to try to do that, it's a lot easier to do on day one when you show up and the ceiling is hanging down than on day 400. A lot easier. If you show up and the place is in shambles and is not fit for human habitation, is unsafe or dangerous because of the housing conditions, there is a provision in the regulations that says you can say, you know what, this contract is void. I'm out of here. And it's a lot easier to make those cases when it's immediate rather than a year, 6 months, 5 weeks down the road, whatever it is. Demand the landlord complete significant repairs prior to accepting occupancy, or at least get a written statement promising to make those repairs. I understand. Yeah, ideal would be to say, no, I'm not going to move in until you bring this place up to code. I understand it's the beginning of a relationship. You don't want to get things off on the wrong foot. I understand you might not have somewhere else to stay, so you may have to move in less than ideal circumstances. But get some commitments from the landlord before you just accept squalor. Okay, and that brings us up to security deposit, which was our stretch goal and we just made it. So I wish that I had more time to take more questions. You're welcome to go now if you want. Because we started so late, I want to go another 5 minutes before I run to my next thing and just try to get through security deposits. But feel free to go now if you've had enough. So security deposits, the key things to take away from security deposits are they cannot be more than 1 month's rent. You can only charge them to a tenant once at the beginning of their tenancy. Now, if you move apartments and sign a new lease, there could be a new security deposit, but there can't be a new security deposit every time you re-up your lease or every time the year rolls around. It's one security deposit once, and it's 1 month's rent at the rent that it was when you moved in. The landlord can't demand that you keep topping it up as your rent goes up. And you are supposed to get interest back from your security deposit if you have lived there for over a year. Technically a year, 365 or 366 days, depending on leap year. Less than that, you just get your principal back. More than that, the landlord had to put it in an interest-bearing account, and they need to give you the interest that they got from that account, whether that was a savings account at Wells Fargo or whatever interest rate they happen to get. Now, we're not talking about a lot of money. I don't have to tell you, interest rates have been extremely low because something happened with our economy 10 years ago. Yeah, exactly. Sorry, I shouldn't get, I'm on government time. I'm not allowed to get political, so. But some, the interest rates have been extremely low. Now, if the landlord doesn't put it in an interest-bearing account, then instead the interest rate they end up owing you, if a court looks at it and says you have to pay them the interest, is what we call the statutory interest rate. That's the rate of interest that the court charges on its own awards. So if you go to court because someone hit you with their car, you get a judgment for $100,000. That judgment's considered an interest-bearing loan. It accrues interest until the person pays it. And every year the court decides what that interest rate will be. It's always higher than the real rate of interest out in the market. But we're currently litigating whether that's simple interest or compound interest, but it's about 4% a year. So with that, I'm going to leave it on this slide describing how landlords return your security deposits because I want to take, if there are any additional questions before I have to run to the next thing. My colleague Harrison will be here in 10 minutes to take over for part 2. Yes, sir, and then I'll come to you, ma'am. No, you probably cannot change the locks. I say probably because the question is, can I change the locks in my apartment building when I don't trust the maintenance workers to have access? The answer is I am relatively certain without seeing your lease that the lease says that you won't. And even if you don't, the owner, even if it doesn't, the owner has the right to have access to their property even though you live there if they give you the requisite 48 hours notice. If one of the maintenance workers breaks into your place and robs it, you could sue your landlord for negligent entrustment, saying they should have known this person was a scoundrel and they never should have given him the key. Or you can, move because you don't trust the maintenance workers. But if you change the locks without the landlord's permission, the landlord could give you a notice saying you have violated your lease, and if you don't correct it, it's the default rule that the owner has to be able to have access. Now, you could probably change the locks and give the owner the new key, but that wouldn't really solve your problem. Yes, ma'am. And then I got to run. So the question is, if I've lived there for 6 years and there have been periods when the property is being repaired, can the landlord deduct those repairs from my security deposit? The answer is, if those repairs were caused by you, not due to normal wear and tear, but due to the tenant's negligence or something that you did, yes, the landlord can take those from your security deposit at the end of your tenancy. They can't take it out of your security deposit while you're still living there, but at the end, yes, they can. I believe so. My colleague Harrison, who's going to be here in a few minutes, he actually doesn't agree with me on that. We were just arguing about it, so maybe ask him when he gets here. With that, we're going to take a little break. Oh, okay. So we're not going to take a little break. I guess we're going to wrap up at 3. Okay, so will the next one start at 3:15 then? Or? Okay, got it. All right, great. So we'll go till 3 so we can go through security deposits. Yes, ma'am. So the question is that the law says the landlord has to give you a 48-hour notice before they can come in, but your landlord's giving you 1 week's notice before they come in? I have to confess I don't see the problem. The landlord's giving you more notice than they have to. Oh, I see what you mean. Okay, now I understand. So the 48 hours notice does not mean the landlord has to give you a 48-hour window, and any time in those 2 days they can show up. It means 2 days before they're going to come, they have to give you a reasonable window of time in which they are going to show up. It does not mean the landlord cannot say, oh, okay, here's my 48 hours notice. Starting 2 days from now, I'm going to come in whenever I want to do repairs for a year. I mean, at that point, there's not notice anymore. So telling you that there's a week during which they're just going to be coming in and out is probably not going to cut it as far as reasonable notice goes. The bad news is that the landlord's failure to give you reasonable notice, in and of itself, you can sue over it. It's trespass, for one thing. The person who comes in is a trespasser. For another thing, it's breach of your contract. If there are damages caused by it, they open the door and they knock over your fancy vase and it breaks. Even if it is not their fault that they did it, even if they did nothing wrong and it was just a crazy accident, the fact that a trespasser broke your stuff means they have to pay for it. It's the you broke it, you bought it rule. If something bad happens when one of those trespassers is in there, they have to pay for it. But on its own, the fact that the landlord isn't following those rules doesn't come with a lot of damages. You can sue, and if you go to court, the court will say, landlord, you have broken your contract. Terrible you. Give her $1 and say you're sorry. I'm serious. They'll award usually a symbolic dollar to show you were in the wrong, but there's no damages for me to award. I think, did you have a question? So the question is, how can we amend a lease if me and my landlord agree? Can we cross it out and initial the changes, or do we have to type up a new lease, or do we have to write an addendum to the lease and sign it? It depends on what your lease says. Your lease may say, this is how we amend this lease. A lot of times the lease just says a writing signed by both parties, and guess what? Crossing something out and initialing next to it, that's a writing signed by both, it's a writing attested to by both parties. You might want to put your signature next to it if it says signed by both parties. Yes, ma'am. So if the question is, do condo laws, bylaws and rules supersede your lease if you're renting from someone in a condo? The answer is, well, the real answer is your landlord should put in their lease that the condo rules are part of this lease, and that violation of the condo rules violates this lease. And my understanding is normally landlords do. Landlords in condos are made aware of, and in fact, often their condo bylaws say you must, if you enter into a lease with a tenant, say that these condo bylaws are part of your lease. And language like that that says the condo bylaws will be part of the lease is fine, is legal, is enforceable. If that's in there, the bylaws are part of your lease, and you have to follow the bylaws too as a tenant. If the landlord didn't put it in there, then the landlord is in a bad spot and did a stupid thing. Yes, ma'am, and then we got to move on. That's a tricky one. Normal wear and tear. It depends on how long you've been there. It depends on what the object is. The question is, are there any definitions of normal wear and tear? The short answer is no. It's a case-by-case issue that judges look at as much as a gut check as it is an application of reason and judgment. A slightly more expansive answer is I use a rule of thumb when I'm dealing with tenants that has typically worked for me in terms of predicting, I think is somewhat close to what most judges do, and that's, did this damage happen because the object in question or the part of the was used in its normal intended way for a long time? For instance, did the carpets get trodden down because people walked on them? Regardless of how trodden down the carpet got, how threadbare, if it's just from people walking on it, that's normal. That's what you're supposed to do with a carpet. On the other hand, if something extraordinary happens, some singular event, even if it's the kind of thing that happens all the time, like you drop a piece of toast on the carpet, even if it's just a little stain, it's probably not normal wear and tear because it happened because you did something accidental to it. There are things that are kind of on the borderline, like nails in the wall, because of course that's something that you're actually actively doing, but at the same time, it's kind of the normal use of a wall to hang things on it. In that case, what you have going for you is precedent, which is cases go through small claims court all the time, and those judges do not think that hanging pictures up on the wall is something that should come out of your security deposit. But there's a lot of stuff on that borderline. Yes, ma'am. Yeah. So the question is, if the tenant has moved out, it's been 90 days, the landlord and the tenant have not communicated about the security deposit, who's at fault, the answer is that the law says the tenant has to provide the landlord with a forwarding address for their security deposit. That is the only action the tenant is required to make. The landlord is required to make the follow-up. If the landlord doesn't do that, guess who has to sue? If you think someone else has money they owe you, you're the one who's got to sue, because that's how our legal system works. So at some point, if the landlord's not returning the tenant's money, yeah, it's the landlord's job under the law to do it. But if you want the money back, you got to go to court. You got to take the landlord to small claims court and say they didn't give me my security deposit back. Yeah, and then it's 3, so I got to go. Yeah, so undercapitalized corporations, the question is, I had a landlord who owned as a corporation, and then the corporation didn't have any money, so I couldn't get my security deposit back. My answer is, remember that thing I said about the economy 10 years ago? 2008. There are problems with the corporate form. Corporations, by definition, limit the liability of the people who own them. And if a corporation runs out of money, there is often a situation where the people who that corporation owes money to, like its pensioners, like its tenants, can't get their money back. And there are limited circumstances in which courts will, it's called pierce the corporate veil, say this corporation was a sham, it was really just the piggy bank of this individual or these individuals, and go after their personal money. It is rare, it is difficult, it is not my area of law. So that's my answer. And with that, I gotta go. I can possibly take your answer offline.